I want to read a little bit to you from the Trump administration's response to CNN and all the other news organizations that have thrown in with Jim Acosta. We went through the Olson, Boutros, and golly, was that a very bad brief, in my view. But who knows with the judge. But here's the response. I haven't read it to myself yet. I just saw it, so I'm going to read it to you as I go through it. Here's their background, their recitation of facts. Let's see if it's better than the Boutros-Olson recitation, which was really quite misleading. Many reporters cover the White House for a range of local, national, and international news outlets. A subset of those reporters have access to facilities within the White House complex, access that requires certain credentials. After completing a Secret Service background check, a reporter may then be approved by the White House for a so-called hard pass, which allows access to the White House complex and briefing room. So you just learned more. You just learned more from that than you did at any other time. On November 7, 2018, President Trump held a press conference to discuss the 2018 midterm elections. One of the attendees was Jim Acosta, chief White House correspondent for CNN, who held a hard pass at that time. At that press conference, as reported in a statement by Press Secretary Sarah Huckabee Sanders, quote, after Mr. Acosta asked the president 2 questions, each of which the president answered, he physically refused to surrender a White House microphone to an intern so that other reporters might ask their questions, unquote. So true. Mr. Acosta, quote, held onto the microphone, unquote, after a White House staffer had put her hands on the microphone and attempted to reclaim it. Later that day, Press Secretary Sanders announced that Mr. Acosta's hard pass had been suspended until further notice. She stated, quote, Mr. Acosta's conduct is absolutely unacceptable. It is also completely disrespectful to the reporter's colleagues not to allow them an opportunity to ask a question. Following that action, Mr. Acosta's application for a day pass on November 8, 2018 was rejected. He was not permitted access to the president's events during a trip to Paris the following day. Also November 8, CNN sent the White House a letter on Mr. Acosta's behalf responding to his suspension on conduct grounds. In that letter, CNN asserted that, quote, the nature and tone of Mr. Acosta's questions was appropriate and newsworthy. Wait a minute. So his tone was newsworthy? Following that letter, the press secretary further explained the decision in a written statement released on November 13. They quote it, we don't need to. Plaintiffs Mr. Acosta and CNN filed their complaint, a motion for preliminary injunction, and a motion for a temporary restraining order on November 13, 2018. This court has scheduled oral argument on plaintiff's motion for a temporary restraining order for the afternoon of November 14. Now, you have so-called legal experts who are not, many of whom have never actually practiced federal constitutional law, who are saying this is a slam dunk, CNN will win. What they're trying to do, ladies and gentlemen, is influence the outcome. That's what they're trying to do. So here's part of the argument by the administration. The standard for issuance of the extraordinary and drastic remedy of a temporary restraining order or a preliminary injunction is very high. They're citing court decisions. An interim injunction is never awarded as of right, and they go on. And a TRO is very difficult to get. I mean, there really has to be matters related to public safety and so forth. Plaintiffs are not likely to succeed on their First Amendment claim. The president has broad discretion in granting White House access to journalists. The First Amendment does not restrict the president's ability to determine the terms on which he does or does not engage with particular journalists. As the D.C. Circuit recognized in Sherrill versus Knight, citing the same case that Ted and Ted cited, the principal case on which plaintiffs rely, the president may, of course, grant interviews or briefings with selected journalists and deny that opportunity to others. Any other result would certainly be unreasonable. The president may choose the journalist he calls on, this is their brief now, at a press conference, or which journalist he invites to an interview in the Oval Office or a press conference, just a large-form interview in the East Room. That discretion extends to his White House staff. the president is free to instruct White House officials to respond positively to particular journalists' requests for information, interviews, or questions, and he's equally free to instruct White House officials to do the opposite by declining similar requests from a different journalist. If the rule were otherwise, courts frequently would be called, these are arguments we made here last night, courts would frequently be called on to police the daily give and take between public officials and reporters, an arena that is defined by discretion and where public officials routinely grant or deny interviews to specific reporters based on their judgment about how the reporter's viewpoints will color the interview. This is a fact, which I pointed out last night. That concern led the Fourth Circuit to uphold the governor of Maryland's decision to prohibit everyone, quote, in the executive department or agencies, unquote, from speaking with two reporters from the Baltimore Sun. Now, here's my question to you. If you're going to have people who call themselves legal experts on this subject on TV, why haven't they cited this information? In reaching that conclusion, the court explained that providing relatively less information to one reporter was permissible, even when done on account of that journalist's reporting. Such decisions regarding the level of access a journalist receives to public officials are a pervasive feature of journalism and of journalists' interactions with government. More broadly, there is no First Amendment right of access to the White House, another point I underscored last evening. As the Supreme Court recognized decades ago, even though any restriction on a citizen's access to the White House diminishes the citizen's opportunities to gather information he might find relevant to his opinion of the way the country's being run, that does not make entry into the White House a First Amendment right. That's a Supreme Court decision from 1965. The president is generally free to open the White House doors to political allies in the hopes of furthering a particular agenda, and he is equally free to invite in only political foes in the hopes of convincing them of his position. The First Amendment simply does not regulate these decisions, and the First Amendment does not impose stricter requirements when journalists, as a subset of the public, are granted or denied access to the White House. The Supreme Court reinforced that the press does not receive special treatment for First Amendment purposes in Citizens United versus Federal Election Commission of 2010. The court said, we have consistently rejected the proposition that the institutional press has any constitutional privilege beyond that of other speakers. A rule that limits the White House's discretion to grant or deny journalists hard passes would thus risk requiring the White House to grant full access to any member of the public who would like to ask the president or his staff questions. You see, this is a grown-up brief. It's not a slapdash, sloppy brief like Boutros and Olson filed. Now, it may not matter, depending on who the judges are and where their heads are at. But it matters to you and me because we own this country, not them. Plaintiff's argument to the contrary rests primarily on the Sherrill case, the only D.C. Circuit case they cite regarding press access to the White House. Plaintiffs rely on Sherrill for the broad proposition that press access should not be denied arbitrarily or for less than compelling reasons. But Sherrill is not so broad. In that case, the sole question was whether the Secret Service had permissibly denied a hard pass to a journalist who the parties agreed was otherwise eligible to receive it for concerns over presidential security. The denial resulted solely from the determination of the Secret Service, after investigating Mr. Sherrill, that he not be issued the pass. The court noted, quote, that all parties to this case recognize the right of a journalist to a White House press pass, assuming that the journalist satisfies some basic objective criteria and is not a source of potential danger to the president or his family. The particular question the court had to answer was thus, what standards govern the Secret Service's denial of a hard pass based on security reasons? In this case, by contrast, it is not conceded that Mr. Acosta is an otherwise eligible journalists. The president has his designees in the White House press office. They've exercised their discretion not to engage with him and, by extension, to no longer grant him on-demand access to the White House complex so that he can attempt to interact with the president or White House officials. Unlike the situation in Sherrill, where only the Secret Service was objecting to the issuance of a pass to the reporter, the White House press office has so objected and thus does not recognize the right of a journalist to a White House press pass in all cases, absent a demonstrated security threat. Put differently, stick with me, put differently, defendants do not concede and in fact reject the premise that the White House press facilities are perceived as being open to all bona fide Washington-based journalists. Such a conclusion is untenable in light of the numerous discretionary determinations the White House press office must make in allocating hard passes to a subset of bona fide Washington-based journalists. For example, the degree to which the requester's beat requires reporting on the White House, whether the requester is a journalist with a sufficiently broad audience, whether hard passes are fairly distributed between comparable organizations, etc. Therefore, the premise on which the D.C. Circuit's opinion in Sherrill depends doesn't exist here. And notice they've been waving it around on cable TV. Look, we got the Sherrill decision. And what did I tell you? That is a D.C. Circuit decision of limited use. And that's all they've got right now. More when I return. Oh, ladies and gentlemen, this brief gets better that the administration filed. I mean, there's no question this is a far stronger brief than what was filed by Ted and Ted on CNN and Jim Acosta and all the gaggle of news agencies that feel the need to circle the wagon around Acosta. But I'm going to get more facts out because you're not getting it on network, satellite, or cable TV. Continuing with the Trump administration's brief. First, plaintiff's own description of November 7 press conference validates the White House's stated reasons for revoking Mr. Acosta's hard pass. In plaintiff's telling, Mr. Acosta asked a question of the president, but the president did not permit him a follow-up. Rather than acknowledge the president's attempt to move on to a different journalist, however, Mr. Acosta continued to try to hold the floor, such that a White House staffer attempted to physically reclaim the microphone Mr. Acosta had been using. Even after the staffer actually had her hands on the microphone, Mr. Acosta continued his refusal to permit another journalist to ask a question, ignoring both the stated wishes of the President of the United States and the efforts of a staffer tasked with helping to manage the event. Listen to this. Second, plaintiffs claim that the decision to revoke Mr. Acosta's hard pass was the revolt of the President's allegedly clear antipathy for CNN and Acosta's reporting. Well, ladies and gentlemen, did you know there are approximately 50 other CNN journalists who retain hard passes to enter the White House complex? 50! 50! I said 50! Let's get back to what I consider a truly grown-up brief from the Trump administration compared to the Crayola Crown brief that was written by Ted and Ted, representing CNN and Jim Acosta, around which the rest of the media have circled the wagons, unfortunately. So we've now learned that there are approximately 50 other CNN journalists who retain hard passes to enter the White House. 50. Plaintiff's complaint, they write, alleges that this antipathy against CNN is long-standing without any plausible explanation as to why there were no allegedly retaliatory actions against Mr. Acosta previously. The more natural explanation for the White House revoking Mr. Acosta's pass on November 7 is that Mr. Acosta's revocation is based on his conduct at the November 7, 2018 press event. Again, that was my emphasis last night. There was a lot of written static thrown into the so-called brief filed by CNN and Jim Acosta. They go on. Third, and relatedly, plaintiff's description of the White House's conduct towards other reporters reinforces that plaintiffs have failed to demonstrate that the White House made a content or viewpoint decision with respect to Mr. Acosta. Again, that was a point I raised last night. Plaintiff's papers include no allegations that the White House has revoked the hard pass of any other reporters, including from CNN, whose reporting the president allegedly disagrees with. In fact, dozens of CNN reporters still retain White House hard passes, as do a number of other journalists who ask him hard-hitting questions. Together, this evidence undermines any claim of content or viewpoint-based retaliation. The better explanation is that the White House responded to conduct that was particularly disruptive to a press conference, with a decision denying one specific reporter further opportunities to cause disruptions. Revoking a reporter's hard pass for impeding the White House's ability to conduct fair and orderly press conferences is not arbitrary. Rather, it preserves the White House's ability to balance each individual reporter's desire to ask questions with the need to abide by norms that permit other reporters to ask questions as well. Indeed, the need to avoid disruptions has long been a non-arbitrary basis for government action. The White House's actions, accordingly, do not run afoul of even plaintiffs' articulation of the relevant First Amendment standards. These are excellent points, well-written, points we raised last night. And if the White House, that is, the administration, gets a fair shake, it should be a slam dunk for them. But again, my first book was called Men in Black, How the Supreme Court is Destroying America. And so you've got to ask yourselves if he will. But he should. This really is a slam dunk for the president. The courts don't want to get in the business of micromanaging a presidential press conference. CNN is not harmed in any respect. And Jim Acosta, being a drama reporter, if you will, being the Morton Downey Jr. of the press corps, he doesn't get to interfere with the press conference. He doesn't get to undermine the other reporters, despite the foolishness of their amicus briefs. This is not a First Amendment issue. This is a perfectly legitimate administrative discretionary decision based on the conduct of this individual as an individual, not as a reporter, as an individual. You don't get to do certain things in a theater. You don't get to do certain things in a courtroom. You don't get to do certain things in a classroom. You don't get to do certain things in a newsroom. And you don't get to do certain things at the White House in a presidential press conference. And should a court rule otherwise, can you imagine the anarchy? And as they point out earlier in this brief, and as I pointed out last night, is the court going to create a cause of action for every reporter? And any reporter who doesn't get a hard pass or doesn't like the way the White House manages press conferences or complains they didn't get a second question? I sure hope the court understands the consequences, unintended and otherwise, that it will create. Furthermore, I hope the court understands separation of powers. It's none of its damn business. This is not a First Amendment issue. And the court should rule against CNN and Jim Acosta, and against all these silly amicus briefs, which are really PR plays by some of these news organizations. They should be able to do that, the court, the judges, but in this case a judge, relatively quickly. I'll be right back. Now, ladies and gentlemen, now that you know the facts about CNN and all the hard passes the company has there and all the rest of it, why would all these other media companies join in on this and claim this is a First Amendment issue? Including some of our friends. Why would they do that? A friend of mine, Terry Pickett, who's also a reporter, she says the White House can grant Acosta conditional daily access on a paper pass, and there he has the same rights as others in the briefing room, many of whom have paper passes, a daily paper pass. But you see, ladies and gentlemen, Acosta doesn't want that because it's a status issue. It's a status issue. You have less regular access. But so what? My question would be this. Why does CNN have 50 so-called journalists with hard passes? Wow, you know what? He's really suppressing freedom of the press, the President of the United States. He really is. We've never seen anything like this. What a dictator. They have 50 hard passes over there at CNN, but they want 51. And they want that one for the biggest jackass in the press corps. That violates the First Amendment. Don't you think so, guys? Yes. USA Today jumps in. AP jumps in. Fox jumps in. Yeah, we're news guys, you know. We're standing up for the First Amendment. No, you're not. How preposterous. And that's why I always look at history and put these things in context. That's why I've explained to you several times now. The John Adams administration, the Abraham Lincoln administration, the Woodrow Wilson administration, the Franklin Roosevelt administration, the Obama administration. Trump hasn't done anything that these other presidents did. Wait a minute. He revoked the hard pass from a guy who wouldn't give up the microphone. Well, that's because he has a hate-on for CNN. Right. And that's why they have 50 other damn reporters in there with hard passes. But then I heard an expert on cable TV, you know, the usual expert. This is a slam dunk case. This should be decided on Friday. No, it may be, if the judge has his head you know where. But if it's a serious judge, the judge is going to have serious questions for CNN. Like, how in the world does this violate the First Amendment and freedom of the press? CNN has more reporters there than the vast majority of reporting outlets in the country. I guess the judge gets to decide who can stay, who can't stay, and we want due process. This is why I am totally disgusted with what Ted Olson has done here. He wants to create a cause of action for a reporter. Beyond the Constitution, a cause of action, an administrative burden on a president, that if you want to remove a reporter, you have to follow these due process rules. They take this case out of the D.C. Circuit, they spin it and twist it into a pretzel, and then they insist there needs to be a due process right. What? That means that reporter has a right to be in that press room. It changes the entire situation. And as I said last night, and these smart lawyers said in their brief, and I'm glad they listened, so if a president doesn't call on a reporter, or if a president doesn't allow a second question from a reporter, what is this due process stuff? Oh, he's discriminated against me because I'm a liberal. He's discriminated against me because I work at the New York Times. He's discriminated against me over my race. He's discriminated against me over my religion. I can hear it all now. I can hear it all now. Because the truth is, the media have become the Democrat Party, and the Democrat Party have become the media. You cannot tell them apart. You cannot tell the news from the Democrat talking points and vice versa. You just cannot. Now, wouldn't this be an incredible irony if a federal court rules for CNN and Jim Acosta on First Amendment grounds, when in fact a judge never holds a press conference, when in fact they don't televise federal courtrooms and what takes place in federal courtrooms? Wouldn't that be an irony? So the federal judiciary wants to monitor and manage a presidential press conference, but they don't hold press conferences themselves. Well, that's because we're different. Exactly. Stay out of it. Butt out of it. This is not an extraordinary circumstance. This is not a freedom of the press issue. It has nothing to do with that. Just because CNN says it does, because they have lousy ratings, just because Jim Acosta says so, they want to pump up their publicity. And it just shows you how terrible the media are today, that they circle the wagons around CNN and Acosta and these stupid arguments. Did the people at USA Today and AP and Fox and these other news outlets, did they know that CNN had 50 individuals with hard press passes? Did they know that? I listened to the network news on my show, which I have no control over. They've never said that. Did any of them actually read the circuit court decision that Boutros and Olson cite, which has to deal with security, has nothing to do with the First Amendment? Did they actually read the case? Do they actually think through the consequences? Should CNN not only be able to destroy itself, should CNN be able to destroy a presidential press conference with this kind of ambulance-chasing litigation? Incredible to me. Absolutely incredible. That is why tonight, on virtually every single news program, on all the cable shows, all the network shows, they haven't thoroughly gone through the White House's response to CNN and Jim Acosta. Instead, the news is all the news groups that have filed friend of the court briefs. Self-serving. Self-serving. Incredible. The truth is, despite what the president says about the press, despite what they say about him, the president's actions against the press have been almost non-existent compared to past presidents. Woodrow Wilson set up a whole intelligence commission within his administration to monitor the media. FDR threatened publishers left and right. Left and right. Senate Democrats issued hundreds and hundreds of subpoenas against telegraph companies wanting communications with publishers and editors. None of that goes on today. You listen to these whiny, thin-skinned, egomaniacal so-called reporters, not all, but too many. Illustrative of Jim Acosta, but apparently all the media is thrown in with Jim Acosta. It's the Jim Acosta media. It's not the Edward R. Murrow media. It's the Jim Acosta media. And you know what? I should stop complaining. It's perfect. They're out of the closet. They've exposed themselves. Every damn one of them. I'll be right back.